Well, the first question is, what is probate? And probate is the process by which a deceased person's will is admitted to probate and their estate then administered, which means gathering in the assets of the will, paying off liabilities, and then distributing in accordance with the terms of the will to those people who are due to benefit from it. Contentious is when an estate becomes disputed, either because there's a dispute about the will itself, or because there's a claim made under a statute outside the will, or there's a dispute between the executors, particularly where obviously there's more than one executor. We often find that they don't have the same ideas about how matters to be undertaken, and that's particularly more so where they haven't got a solicitor acting. So it is quite important, particularly if it's going to be a rather argumentative estate, to ensure that you instruct a solicitor. Sometimes also you can have disputes between the executors and the beneficiaries, i.e. those who stand to benefit under the will. Well, firstly, the will must be properly executed, and that means it must be signed by the person who's making the will, and their signature needs to be witnessed by two witnesses who are independent. Since COVID, there has been a provision for wills to be witnessed through video, but by and large, that's not being used so much now. The second point is that the person must have the capacity to make a will, and obviously with much older people and unwell people, that can be thrown into question. Another issue would be forgery, for example, where signatures are forged by a third party for their own ends. That's quite unusual, but it does happen very occasionally. And then lastly, there's something called undue influence. Now, everybody influences everyone every day. So just because somebody's been talking to somebody and that's affected their views about what they want to do, that in itself is not going to make a will invalid. But if somebody makes a will under coercion to the extent that they're no longer making it of their own free will and free decision, then that would open up the allegation of undue influence. That's particularly likely to occur where somebody is sitting in meetings with the person who's making the will and doesn't let them have free access to a solicitor. Now, in all these cases, I think having access to a solicitor is likely to reduce the allegations regarding invalidity of the will. Homemade wills are most likely to be open to challenge. Well, the most likely claim, and we see a lot of these, are claims brought by close family members under the Inheritance Provision for Family Independence Act 1975. And this statute allows spouses, cohabitees, civil partners, and sometimes ex-spouses, as well as children and those financially dependent on the person who has died, to bring a claim on the basis that the will fails to make reasonable financial provision for them. We have to go through quite a lot of detail with them in working out whether they satisfy certain criteria, but it's certainly worth investigating if you are falling into one of those categories and you've been left nothing in a will. There are other claims as well, but those tend to relate to specific sets of circumstances, such as, for example, having been made a promise by the person who's died, relied on that promise and acted financially to your detriment, and now finding that the deceased has gone back on that promise. There are also other claims relating to property, where promises have been made in relation to property, and perhaps you've put money into property with the deceased, but you're not on the legal title. There are many other claims too, but they're slightly rarer and would only apply in specific sets of circumstances. But I think the advice I would give is, if you're expecting to receive something under a will and you've been left nothing or less than you anticipated, then it's always worth speaking to a solicitor to see if in fact there is a claim and that in fact the situation can be put right. Well, the first step is to come and get some legal advice. We will take full details, advise you what sort of claims you might have or whether you have any at all, and then start by engaging in correspondence with the other side. Well, that depends. It depends on whether you manage to settle the matter following correspondence, maybe engage in negotiations, attend a mediation, in which case we could be looking at 6 months, 9 months. If you issue proceedings and it goes all the way to a final hearing, then you could be looking at 2 to 3 years or longer.